Happy Halloween and welcome back to the Financial Symmetry Show, where we dive into opportunities and strategies to help you live your ideal retirement. I'm Allison Berger, and I have a very special guest joining me today to tackle some tales from the crypt for retirees to be aware of. Before we get into today's topic, we know the current economic and market environment is particularly scary for those in and on the cusp of retirement. So we want to invite you to download our pre-retirement checklist, as well as a game plan for volatile markets. You can find these resources on our website and in the show notes for this episode. Without further ado, I want to welcome estate attorney and our crypt keeper today, Adam Tarsitano. Adam also joined us in episode 165 to discuss the importance of a professionally prepared estate plan. And we're happy to have him back.
My pleasure. Thanks for having me.
Yeah, so as we're heading into retirement and really throughout our lives, one thing that's true is none of us knows exactly how long we're going to live. And unfortunately, we can't take our hard-earned savings and investment with us. So we want to make sure that your wishes are laid out appropriately. This is a really critical component of your retirement planning journey. So Adam's put together some tales from the crypt that he's seen along the way that we want you to be aware of. So Adam, why don't you start off and tell us about the law offices of Frankenstein and Elvira?
It is a great law firm. They have great reviews on Google. And so if you're just kind of looking for an attorney and they pop up, you might be impressed with what you see. But most of those reviews are from their family law practice, from their criminal law practice, maybe their litigation practice, but really not too much about their estate planning practice. The main takeaway from Frankenstein and Elvira is you want to make sure that they have a dedicated estate planning practice because they might be incredibly good at family law, incredibly good at criminal law, but unless they have a dedicated estate planning practice, you could end up with less than you bargained for.
Yeah, so what could go wrong when you use someone who is not a dedicated estate planning attorney? So maybe you have a friend who works in divorce law or they do some other type of law and they say, "Oh, I'll do that for you. Don't worry about it. You don't need to hire somebody. I can take care of that." What could go wrong in those situations?
Sure. Primarily, it is the firms that don't do estate planning as one of their primary practice areas. They tend to use forms, and they're very sort of married to forms. So they're good at obviously plugging in names to pre-prepared forms, but they're not going to provide the analysis that's necessary to get the type of estate plan that you need. Whereas with an estate planning attorney, they'll find out the client's goals, they'll analyze those goals, and then they'll put together a plan that matches those goals. It may be a very simple plan in the end, but it's the analysis that matters. That's what counts. That the attorney knows what to look for, whether it be the type of plan you need, how to set up your beneficiary designations, tips to help avoid probate. Those are the kinds of things you're going to get from an estate planning attorney that you just might not get from someone who is either helping you out as a friend or someone that kind of just dedicates a very small piece of their practice.
So maybe they dabble, but that's not their dedicated day to day.
And it is common. A lot of firms do dabble in estate planning because they download a set of forms or they obtain a set of forms and they think, well, I just got to get some names, plug them in the forms, and I've generated some revenue for my firm. But it's just not that simple.
Yeah. And one thing you've mentioned and you caution is that throughout this process, once they've put the documents into place, they've done all this prep work, clients can be ghosted, right?
Yes. And of course, that term was chosen for our theme here, but absolutely. So the main thing is that before you sign the documents, before you leave your attorney's office, whether it be a dedicated estate planning attorney or someone else, you want to make sure that you understand your documents. What do they say? Make sure you ask any questions that you have. A good estate planning attorney will always, of course, even after the fact, after you've signed, respond to questions that you have. Because a lot of clients get home, they open up the documents, they take a second look, and all of a sudden they're like, well, you know what, I don't know what this means. They can always reach back out, and like I said, a good estate planning attorney will explain it to them even then. But a client will feel so much better when they leave that office with the confidence of knowing what the documents say, that they accomplish all of the things that they wanted them to accomplish, as opposed to getting home and then being like, what did we do? I don't know what any of this means.
Poof, you had mentioned that. They can
Yeah.
feel like, poof, the documents are done and we don't really know what just happened. Some good tips there to be aware of if you're in the process of preparing your estate documents and working with any attorney, as estate attorney or not. So this brings us to another creepy tale of attorneys at the corner of Spooky Lane and Money Pit Drive. Oh, so tell us about these law offices of Dracula and Wolfman and what we should be looking for there.
The takeaway from that particular law firm is that estate plans come in many different sizes. And there are certain firms that no matter what you go in there with, you're always going to come out with an extra large plan, something complicated. Not everybody needs complicated plans. And so, again, it's really the idea of you want an attorney that's going to analyze your specific goals and prepare a plan that fits your specific needs, as opposed to you coming into an office and them saying, we're going to give you a beautiful revocable trust. We're going to even set up some irrevocable trusts in case you want to do Medicaid planning down the road. You're going to leave here with a binder that's this thick, that has everything you could possibly need to get you to the finish line. And that's just not the approach that estate planning attorneys typically take. It usually is, what do you need? And that's what we're going to give you.
Yeah, and I'm noticing a little bit of a theme of a buyer beware in these stories, right? Things we want to be on the lookout because you're hiring a professional in this process. And I think a lot of people make the assumption that this is an attorney and they're going to do a great job for me. They know much better than I do.
I think we all have a sense of how a process is going. And, if things are going right, you're going to feel confident, you're going to feel empowered, you're going to feel like you understand what's going on. But if you're feeling something other than that, you're feeling confused, you're feeling like maybe you're being sold something as opposed to working with your attorney to come up with a plan, that's not a good feeling. And that's typically, there's a reason for feeling that way. And it might be that you're not getting what you need or what you want, or that maybe you're paying for something that you don't need.
That's a great tip. I'm glad you brought that up. In financial planning as well, you want it to be a collaborative process where your voice is being heard. And then, so you mentioned, revocable trust, irrevocable trust. What are some characteristics of families or individuals where those more complex techniques might be necessary?
Sure. So the one that everybody, I think, is probably aware of is high net worth. Because with high net worth, there's always the chance that you could have to end up paying estate tax at the time of your passing. The exemption amount is very high right now. Most people are not worried about that. But if you're up in that range, you need more complicated estate planning, and that could include various kinds of irrevocable trusts. Another one, though, would be that you simply have complicated goals. And complicated goals could be an array of things, but it could be, for example, that you want, various amounts of your estate to go to charities in varying degrees, varying percentages, and then you want certain amounts going to family members, but some of those family members can't receive those things outright and free of trust. They need them to go into a trust because maybe they're a minor, maybe one of them has a special needs. And so they come to you with these goals, and the goals are complicated. And so complicated goals require a more complicated analysis. Now, it may end up being that the documents themselves are still pretty simple, but the analysis is more complex. And then finally, one that does happen quite often is blended families, second marriage type situations. And again, the documents may end up being simple in the end, but the analysis is always more complicated.
You mentioned a crummy trust in there. Can you give us a little bit more, maybe in layman's terms, what that might mean?
Sure. So the crummy trust is a tool used to fund a trust where you're coming in under the yearly gift tax amount. Most trusts, when you give to a trust, it's considered a gift. And so a gift erodes your estate tax exemption. However, with a crummy trust, they actually count it as being a present gift interest because you're giving the potential beneficiary a right to take that money immediately. That's it in a nutshell. But basically, what it does is it allows this to grow underneath the gift exemption amount. And again, it's a legal fiction, but basically, because you give the beneficiary the right to take that money immediately, and you hope that they don't, of course, it actually is considered a present interest. So there's a lot of benefit to it.
So once again, falling into that high net worth demographic. And when we say high net worth, how would you define that in estate planning terms?
The sort of standard that I always would go by would be the estate tax exemption amount for any given year. Right now, it's over $12.5 million. And so, and there's something called portability, which essentially doubles that amount for a married couple. So the second spouse really would pass away with over basically a $25 million exemption from estate tax. But the thing there is that that's always changing. It changes by administration. And so you never really know what that amount is going to be at the time of your death. But my suggestion would be if you're getting close to 10 million, 11 million, 12 million, you want to at least start thinking about things you can do to start lowering the value of your potential estate.
Okay. And how about, so a question I hear from clients frequently, should I put my house in a trust?
So my answer to that is it depends. The only way to completely avoid probate would be to have a revocable trust in place and actually put your assets into that trust. Because a revocable trust is just a piece of paper until it's been funded. If you do have a revocable trust, you want to make sure you speak to your attorney about their suggestions regarding the timing of funding the trust, how to fund the trust. Because oftentimes, if it's a married couple, they own the property or the home jointly anyway. So when one of them passes away, it's simply going to pass to the surviving spouse by virtue of that joint ownership. It may not be necessary to put that house into the trust until the second spouse passes, or until the first spouse passes away. The second spouse can then transfer into the name of the trust.
Okay, great. So I know this brings us to our final tale from the crypt today. So we are now turning to a highly respected estate attorney. So we're on the right track, right? His name is Mr. Bonejangles. What could go wrong?
Well, so in the case of Mr. Bonejangles, it's more about what we talked about earlier, which is making sure that you view the estate planning process as a team effort. So Mr. Bonejangles routinely sends his potential clients what we call an estate planning questionnaire. It seeks information about their estate planning goals, asks about their assets, typically asks for who they would want to be, of course, their beneficiaries, their executors, their agents for healthcare power of attorney purposes, for financial power of attorney purposes. And it does ask for details. And the details that are typically the ones that potential clients leave out are middle names of beneficiaries, for example, or they don't provide a full address for the folks that they're going to designate on a healthcare power of attorney, or the uncle they're going to name as executor, they forget to put their uncle's middle name. And now those might seem like little details, and of course, a good estate planning attorney like Mr. Bonejangles will follow up with them to get that information. When everybody's kind of working together and following the directions together, the process is just smoother. And so the takeaway there is that, of course, the attorney is going to do the heavy lifting with respect to the analysis, with respect to preparing the documents. But if the client looks at it as a team effort, it can only be a better experience.
Yeah, so it sounds like you get out of it what you put into it with a lot of other things.
A good attorney is going to get that information, and that information will end up being in the documents. But it's more having the client go through the process. It's all a process. And so if they're sitting there and they're concentrating on that estate planning questionnaire and they're filling it out properly, it's not just that they filled it out properly, it's that they've mentally gone through all of the checks. They've thought about it enough, they've cared about it enough to make sure that they're including their uncle's name, for example. That's really the important piece. It's not so much that you get a document where somebody forgets a middle name. It happens. But it's going through the motions to make sure that what you're turning into the attorney represents what you want in your estate plan.
Great advice. I had a high school teacher who always used to say neatly and completely. That reminds me of that. So we can tell our clients that as well on the paperwork. Remember, neatly and completely. Thinking about what is with all of these, what is scarier in estate planning than watching a horror movie on Halloween night with the lights out?
Sure. And I say that I'm going to say this kind of in jest, but the thing that everyone dreads the most when they talk about either estate planning or what happens after is probate. Probate is sort of a dirty word when it comes to estate planning. It's even better, though, when you have an attorney that's going to walk you through all of the steps that you can take to avoid probate, or at least to minimize probate, because there are ways to completely avoid it, and then there are ways to minimize it. And both can be very effective tools for clients to, avoid the horrors of probate. North Carolina, in particular, probate is not difficult. It is simpler than a lot of states. It is less costly than a lot of states. But to the extent that you can avoid it or minimize it, you want your attorney to guide you through all that.
And tell us about, since we're talking about probate, tell us about the practices in North Carolina around the family home.
It depends on who your client is, but I like the example of the married couple because it gives you a few different kind of scenarios. But essentially, most folks who are married own their property in North Carolina as what we call tenants by the entireties, which is a special way that folks who are married in North Carolina get to own property, and there are certain liability advantages to owning property that way. But either way, it's jointly owned. So when one spouse passes away, it's going to pass to that surviving spouse by virtue of that joint ownership. So it's not going to go through probate at that first death. At the second death, if there's no revocable trust and that property is still in the name of that surviving spouse, and say the will says, well, everything goes to their kids in equal shares. Well, in North Carolina, real property does vest immediately in the beneficiaries. The house would be listed, but it wouldn't really be considered part of the estate. Now, if you had a revocable trust, when that first spouse passes away and it passes to that surviving spouse, at that point in time, if you had a revocable trust, that's when you would certainly want to make sure that you deeded a home from that spouse's name into the trust. Because then, when that person passes away, it's not theirs anymore, it's owned by the trust. And so the trust then would determine what happens to it. It goes to the kids, whatever the case may be. And in that way, it's completely outside of probate. It's not included on any documents. It's completely separate. And that's true for all assets if you have a revocable trust and the assets are titled in the name of that revocable trust.
And that can be if you want privacy as well, right? Because probate more is public with a probate.
So a revocable trust as long as you have the revocable trust and you've taken the step of making sure your assets are in the trust at the time of your passing, then yes, all that stuff passes completely privately without the need to include it on any of the forms that might be public. And even the will typically would just be what we call a pour over will. And a pour over will really just says, hey, everything I've got at the time of my passing is going to pour over into my revocable trust. So very little is available for public consumption if you're interested in privacy.
That sounds great. And I want to touch on something you mentioned earlier about Medicaid planning. How much of this do you see, and what are some of the pros, cons, or pitfalls that we want to consider in North Carolina?
Well, this is an excellent point for a lot of reasons, and I'll explain why I say that. This is where I would tell you that in that case, you want to speak to an elder law attorney. You want to speak to an attorney that practices in elder law. Because I could sit there and give you advice as an estate planning attorney, but it might not be as good as it would be if you were talking to someone that did elder law planning. And so I'm kind of heeding my own advice there. But there are multiple ways to prepare for qualifying for Medicaid. Typically, it includes spending down the assets that you have. But that can be done in multiple ways, through irrevocable trusts, through giving away property. If you're looking to get detailed advice about that kind of planning, you want to speak to an attorney that not only does estate planning, but really that focuses their practice on elder law care.
Okay, perfect. That's great advice. And we see this, I think this is a common financial planning or estate planning misconception, I think, is getting the income or the assets down when really in North Carolina to be eligible for Medicaid, your income needs to be below about $19,000 a year for an individual, which is, for many, many retirees, their Social Security alone may be higher than that. So that can be a challenge.
What a lot of folks don't consider, especially the folks that actually could afford long-term care on their own, but kind of want to preserve those assets for folks down the road, the care that you're going to get from Medicaid is not going to be as good as the care you would get from using your private money for a facility. And so you're basically saying, okay, well, I want to put my assets aside so I qualify for this governmental program. So it's kind of an interesting area. But in terms of the nitty gritty, an elder law attorney is usually the best person to speak to about it. Estate planning attorneys like myself, we know little tricks here and there. For example, if someone just really wants, and we talked about this earlier, kind of ties in with the real property, the home. If someone was looking to transfer their home to their children, for example, to get it out of their names, if you do that with a life estate, that could actually be something that could benefit you in trying to qualify for Medicaid. But again, beyond those kind of simple tricks, you would want to speak to an elder law attorney about different irrevocable trust options and things like that.
Okay, great advice. And then, as we're moving through this Halloween season and enjoying the fall, I know pumpkin spice is on everybody's radar. It's in all our beverages and our cookies and our pies. Tell us what we want to be looking for as we're enjoying our pumpkin spice goodies.
So the point there is that, and I used pumpkin pie as sort of the example. The custard, that pumpkin flavored custard is delicious. But it's not by itself a pumpkin pie, right? You need the crust, you need the spices, maybe you like a little dollop of whipped cream on top, whatever, But the point being that it alone is not a pumpkin pie. Same thing with a will. A will is probably the most sort of well-known document. However, that is not an estate plan. An estate plan these days, at a minimum, consists of a will, a healthcare power of attorney, a financial power of attorney, and usually a HIPAA authorization. So that is what constitutes an estate plan. Now, there are plans that are more complicated than that. That's why I said at a minimum. There are plans that involve revocable trusts, irrevocable trusts, various other types of documents. But at a minimum, when you leave your attorney's office expecting to have an estate plan, it should be the will, the healthcare power of attorney, financial power of attorney, and a HIPAA. And so that when you get home, you've got what happens at death covered with your will, but you've also got the documents necessary in the event you become incapacitated and you can't make healthcare decisions anymore, can't make financial decisions anymore. But one thing that most people actually do find to be more horrific than probate is guardianship. And guardianship is what results when you don't have your power of attorney documents in place and you become incapacitated. Instead of being able to hand over a power of attorney document, it's called a guardianship proceeding, and they're usually really challenging.
So I know, Adam, you've given us some great advice today, and hearing all these spooky tales and buyer beware stories might make some of us feel a little frozen. So what are your progress principles for individuals and families that may have been procrastinating or they're trying to implement this right now? How can they move forward?
The main takeaway is that you need to find an estate planning attorney to take care of your estate planning. And there are plenty of estate planning attorneys out there that do a great job that aren't going to engage in any of the things that I've talked about today that are spooky or scary. And so, when you're looking for an attorney, you've decided it's time to get these things done, just take the extra time. And this is what I was talking about, just take that extra time to find firms that have estate planning as a primary practice area. And if you do that, then at least you're starting the process at the right level. The other thing I would say is just telling folks that it is important to have these documents in place. Nobody, like you said in the very beginning, likes to think about their own demise, what's going to happen when I pass away. But estate planning is really something that you're doing for the benefit of the people that you leave behind. For example, if you have minor children, you need to make sure that you have a trust in place to catch a share going to those minor children. Because the last thing you want is for 18-year-olds to get complete control over the money that you've earned over the course of your lifetime, because it will be gone by the time they're 19. So with a trust in place, you have someone more mature, more responsible managing those monies for them. And quite frankly, it's the responsible thing to do for your family.
Yeah, well, Adam, thank you so much for putting these stories together. This certainly gives our listeners a lot of food for thought and more than just candy. I would say some nutritious ideas coming out of the podcast today. So you
Well,
can
good.
put that with the raisins and the pretzels that you're giving out with your candy this year. And, at Financial Symmetry, we're passionate about helping our clients enhance today and enrich tomorrow on their retirement journeys. If that sounds interesting to you, please reach out and find more information on our website at financialsymmetry.com. You can also download our estate planning checklist to help you avoid some of the pitfalls that Adam described today. Adam's contact info will also be linked in the show notes, so you can reach out if you have specific questions about your personal estate plan. We put these episodes together every 2 weeks. Please subscribe if you don't want to miss the next one. Thanks for listening.